Alrighty, this is Weed People News. Okay, not going to go into a lot of great details because this is going to be a fairly long video. But this is about the 1871 Civil Rights Act. That 16 words are missing. I did a video previous to this. And by the way, this is by C.J. Grisham. And he's on his YouTube is Texas 2 capital A Second Amendment. Okay, attorney C.J. Grisham. Okay, so if you want to check it out, the whole video of his, I'm just kind of spot checking to give you a little insight. Okay, let's proceed forward on this. Okay, how did 1781 become 42 U.S.C. 1983 today?
Myself. So this is Section 1983. This is what we have today. This is what the Supreme Court has, when it created qualified immunity, this is what it created qualified immunity from, is 42 U.S.C., so Title 42, United States Code, Section 1983. This is a civil action for deprivation of rights. In order to get around the sovereign immunity, theoretically, under the common law, the only time you can sue government is when government gives you permission to sue it. That's what 1983 is. 1983 is Congress saying, okay, we are giving you, the people, the right to sue the sovereign under these circumstances, right? And these circumstances are deprivation of rights. So every person who, under the color of any statute, ordinance, regulation, custom, or usage of any state or territory or District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any right, privilege, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress, except that in an action against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. Now, I'm not going to get too much into this.
Not attorney, but I wanted to point out, it says judicial, judges, not administratives. Okay, they're not judges. So you can actually sue the administrative under the same category as officers that we'll get to.
Last part, but what I am going to tell you is that since 1871, when this law was initially passed, there's only been one amendment. And that one amendment to 1983 is right here, except this part right here. And the reason for that is and this, I believe it was in 1996 when this was updated and this amendment was added. And all they did was make it harder for you to sue a judge for doing his job.
Side note, 1986, they also changed the oath of office where it says everybody obeys the Constitution. But in 1996, they extended words in there saying, and the law of the state or the law of the federal government and all that kind of stuff. But before that, before 1996, it was just obey the Constitution, period. Okay? So, let's go ahead. Oh, but
it's still...
That was under Clinton administrative, or Clinton years.
It does provide a very narrow path if you do need to sue a judge. So we're going to keep that out. But I wanted to highlight to you that since 1871, the only amendment that Congress has passed to what we know as 1983, 42 U.S.C. 1983, is what I've got highlighted right here, where they essentially made it harder to sue a judge or a justice, okay? That's it. Other than that, everything else here is untouched, theoretically. But I did a deep dive. And started looking into, because I'm trying to figure out what is the history of 1983. Well, here's the history. The history is this, and let me go back to this, add this up. This is, I'm sorry, yeah, 1871, here we go. Let me get this out of the way. I don't know if y'all can see that or not, but I can. This is what we consider, it's called the Civil Rights Act of 1871. This was passed on April 20th, 1871, and this is the law itself. Now, this might sound familiar, right? Be enacted by the Senate and House of Representatives of the United States of America and Congress assembled. And then here we go. Any person who, under color of law, or any law, statute, ordinance, regulation, custom, or usage of any state shall subject or cause to be subjected any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States shall, any such law, statute, ordinance, regulation, custom, or usage of the states to the contrary notwithstanding, be liable to the party injured in any action by law, suit, or equity, or other proper proceeding for redress, such proceeding to be prosecuted in the several districts. And it talks, this stuff is all codified elsewhere. But it ends essentially right here, proceeding for redress, right? And you notice in the original 1871, you don't see the part about judges. And that was added. That wasn't added until 1996. So you see that, right? You see that. Now I'm gonna bring to your attention something here. I don't know if I can highlight any of this for you. Never mind. Let's just not do that.
My internet.
Place and have civil rights statutes, if you wanted to know what civil rights statutes. And then they gave them a new number. So what was the Civil Rights Act of 1871 became Title 24. Whoops. Oh my goodness. I just skipped. Okay. Became Title 24 Civil Rights, Section 1979. Stop. What are you doing? See, I'd rather have my own computer. This is what happens when I'm on the road. So, and you can see right here where it says 20 April 1871 becomes Section 1979. And then you can read here, this is what was passed on April 20th, 1871. Every person who, under color of law, of any statute, ordinance, regulation, custom, or usage of any state or territory, subjects or causes to be subjected, any citizen of the United States or other person within jurisdiction thereof, the deprivation of the law. Okay? But wait, is this the April 20th, 1871 law that was passed? And I thought, this looks pretty short. And if you remember, go back to this is kind of a long paragraph. And I realize this is bigger, the font here, but I'm like, this just looks a lot thicker than what we were just looking at. And as you compare them, so then what I did was I printed this out, right? Printed this out. Then I printed this out right here, Section 1. And I compared them. And what you're going to notice here, this is what I can't do. But I want to pay some, this is what was passed, what you're looking at right now, on April 20th, 1871. This is what was passed by Congress. And what was passed by Congress includes these 16 words. Any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding. I'm going to read this one more time. I want you to get this into your head. Think about this. Try to memorize it with me. Try to remember. Follow the bouncing ball. Keep this in your mind. This is the law that was passed in 1871. Passed by the House, passed by the Senate, signed into law by the President. any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding. Those 16 words right there. Any law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding. What does that mean? What it means in everyday usage is you cannot claim a common law defense. That's what this means. There is no common law defense to this section of the Civil Rights Act. So if you violate someone's rights, they can sue you. And that's it. It doesn't matter what a law says. It doesn't matter what a statute says. It doesn't matter what an ordinance says. It doesn't matter what a regulation says. It doesn't matter what your immunity says or usage of the state, how things were done in the past. To the contrary, notwithstanding, those things don't matter. That's what this means. These things do not matter. Okay? If you violate someone's rights, they can sue you. Don't go hiding behind a common law defense. Well, if you go back to here, remember those 16 words? Oh, stop it. Remember those 16 words? I want you to find, here, let me do this. Oops. Let me do this. Come on. There we go. And let me minimize that a little bit. I'm going to put these side by side. Here we go. That's the original law. This, stop it. There we go. When the compilers, whoever was tasked with compiling all the laws into the first revised statutes of the United States, took this over here, the original law, and enacted it into the code, into section 1979. Now, here's the problem. These two aren't the same thing. There's words missing from section 1979 and 1874. What you will not find, and what does not exist, is a congressional act that amends section 1979 here. Oh my gosh, it's driving me nuts. That amends section 1979 here. Essentially what amends the Civil Rights Act of 1871. We are missing where Congress said, you don't get qualified immunity. Now keep in mind, qualified immunity didn't exist back then, but you don't get your common law defenses that you would traditionally have. We are saying people can sue you if you violate their rights. Stop violating their rights. Stop treating black people differently than white people. That's what this was about. That's what this law was about. And if you do violate their rights, don't think you're going to hide behind, oh, well, I'm the sovereign. You can't do that because it says right here, sorry, customs and usage of the state to the contrary don't matter, notwithstanding. This is the new law. You can be sued. So then what happened in the future? Let me turn this off again real quick. It was, so 1871 was the Civil Rights Act. And in 74, they compiled all of these statutes at large, including the Civil Rights Act. And someone, we don't even know who. We don't know who was in charge of transcribing all these laws and organizing them by section. And so we don't even know what laws there might be even laws out there that do even more that we're unaware of because they were never transported over unless you take the U.S. Code today and you take the revised statutes of yesterday and compare them to every single law passed by Congress since 1776, you are not going to probably be able to even understand that. I mean, you've got to think back then, people are literally in there transcribing every single law and compiling them into this on a typewriter, compiling these things onto a single document. There might be spelling errors and all that kind of stuff. And yes, there were, because there was a second revised statutes of the United States. So, but from 1874, miraculously in 3 years, 16 words disappeared from 1983 in the revised statutes. And then you've got the civil action. You've got when the U.S. Code was created, it took those revised statutes and again changed. So what was the Civil Rights Act of 1871 became Title 24, Section 1979. Title 24, Section 1979 became eventually Title 42, Section 1983, as we know it today. And it was Section 1983 that the Supreme Court had access to when it invented out of thin air this idea of qualified immunity. And the reason they did that is because the Supreme Court could not see those 16 words because they didn't exist. As far as they knew, they were sitting there reading the U.S. Code, and the U.S. Code doesn't say anything that your common law defenses notwithstanding.
And we're going to end it right there. So, even common law, if you go after, we talked about previous video, a man going after the man, that's common law. So, it still can work that way. You cannot go after him in civil of the Roman Code, statute, rules, and regulations, but you can go after him man to man. Okay? Now, if they get this, and CJ is going to try to get this into the Supreme Court to get rid of the officer's qualified immunity, but the word officer is broad. All right, CPS is an officer. Okay, magistrates are officers. Your assessor is an officer, right? So people are better than me at it. Create a notice of liability, of trespass, and use that document right there to have the standing you need. Okay. Then you're going to have to give orders or commands to the magistrate or judicial judge, even if it's in a lower court. Well, it don't matter what the Supreme Court said. You cannot break the law, or you are going to be held liable, not the Supreme Court. So you got to give them that notice as well. Allegedly. These are We the People News. Till next time. Bye, y'all.